Thank you so much for joining us. My name is Gali. I'm a doctoral fellow at the Ash Center, and I'm organizing this study group on the US labor movement, opportunities and challenges with Dr. Johnnie Lotesta. She's also a fellow at the Ash Center. So this is the fourth and final session of the workshop. Our first session was about organizing workers on the fringes or outside the National Labor Relations Act. And then we had another session about the intersection between the US civil rights and the US labor movements. And last week we had our third session about the effects of COVID-19, health, and economic repercussion on the workplace, on working people, on organizing. And I think that this kind of trio of session prepared us well for today's session, which will talk about the future of US labor policy, US workplace regulations. For today, we're talking about the future of US labor policy. So to do that, we have two wonderful speakers. We have Professor David Weil. He's the Dean of the Heller School for Social Policy and Management at Brandeis. And we have Sharon. She's the Executive Director of the Labor and Work-Life Program here at Harvard Law School. Both are tremendously influential folks in how people think about today's workplace now and how we should think about what are the challenges and opportunities going forward. And I think that the overarching question that I have for today is what are the necessary components or ingredients for future labor and workplace policy in the US? And once we have those, we can maybe discuss about how the COVID-19 issues affects about how it is that we think about workplace regulation, about workplace power, workplace voice. So this session is recorded, so please be minded of that. We will read out loud your questions in the chat option. I think that this is the anti-Zoom bombing measure that we took, right, Johnnie? Great. Anything else that I forgot, Johnnie?
No, I think that's it. I'm looking forward to the discussion.
Great. So each speaker will have about 10 to 15 minutes, and then we'll follow with the Q&A. David, Professor Weil, the floor is yours.
Okay. Well, thank you, Gali. Thank you, Johnnie, for inviting me. I was looking forward to seeing you all in person when I think we first scheduled this, but I'm delighted to join you today for the discussion. I'm always delighted to be on a session with my good friend Sharon Block. Sharon and I were in the trenches together during the Obama administration in the Labor Department, and I certainly we faced many of the issues that I think we're going to talk about today in that context, and can talk about sort of any number of issues from the perspective of what I think we both learned from that experience and thinking about labor policy questions in the current context. So I want to start my comments about which are really going to be focused about labor policies, the future of labor policy in regard what is sometimes called employment law. It's the laws regarding labor standards, health and safety, to some extent discrimination laws, a lot of the things you've talked about, and certainly intersect with the world of collective voice and representation and organizing, which we group somewhat arbitrarily as a labor policy, but that's clearly what Sharon has been leading a major initiative on, and we're kind of dividing the remarks around that, but I think the intersections are also important for us to discuss. I want to start my brief remarks really by going back in time a little bit and talking first of all about, we're talking about the future of labor policy. I think it's important to ground it in why we regulate the workplace in the first place. And though how we do it and the nature of the regulatory problem and all kinds of features about the process of regulating the workplace are very much dependent on current economic, technologic, social realities, I think there is a fundamental principle behind workplace regulation that we should never lose sight of. And I came across this recently, this wonderful quote from a pivotal decision in US workplace law by Justice Charles Hughes, ruling in a very famous case called West Coast Hotel v. Parrish, which was a pivotal moment in labor policy history where the Supreme Court flipped from basically striking down any state level and federal effort to regulate the labor market to allowing that activity, going from some concept called liberty of contract to something that really acknowledged the public interest in the regulation of the workplace. And in that decision, Justice Hughes says, the exploitation of a class of workers who are in an unequal position with respect to bargaining power and are thus relatively defenseless against the denial of a living wage is not only detrimental to their health and well-being, but casts a direct burden for their support upon the community. So linking the reason in this particular case of regulating minimum wages to not only the welfare of the individual worker, but to the community, I think that has resonance for reasons I'll talk more about, obviously, in the current moment. But even before getting to that part of the quote, I want to start with this idea of unequal bargaining power. And I think that's something we so often lose. And in some of the debates I think we have had, at least till recent times, have lost this as a principal reason about why we do things like regulate health and safety, why we regulate minimum wage and overtime. And it is an acknowledgement that one of the distinctive features of a labor market is the unequal position of workers relative to the people who hire workers. And I don't want to say employers because that's part of what I want to talk about. It's not always employers in the context of how we define that under law, but it is the party or parties who get value from that work that is almost inherently an unequal position why we intervene. And I think that therefore sets up a notion about what we need to do to intervene and why in the present workplace our policies are often leave major holes in the protections, in the acknowledgement of that unequal bargaining power. And that's where I'll jump from 1937 to 2020, because one of the takeaways, and I think there's been a lot of discussion about what the pandemic has revealed about the inadequacies of workplace regulations, are the holes laid bare I group them in two bundles. One is a whole set of policies that the United States has been remiss in putting forward till recent times. Obviously, healthcare, which we took a huge step forward under the Affordable Care Act, but we have seen this administration roll back, but the fundamental importance of having comprehensive healthcare protections. The absence until recently and only at the state level of comprehensive sick day and paid leave programs has been laid bare, and again suggests why we need to have this more comprehensive view about our collective interests in protecting workers because of the community effects on those workers. That's one realm. In the realm of something that I've, both as an academic and as the head of an enforcement agency, have thought a lot about for a long time, and that is who's covered and who falls outside of our workplace laws. And this is where I would cite the restructuring of businesses that people talk about as if it only started with Uber and platform economies, but as I have long held, really began in the 1980s with in many ways, the dismantling of the employment relationships because of changes in the larger structure of business organizations that has continued to go on, and manifests itself in lots of different organizational forms, ranging from the prevalence of independent contracting and the misclassification of workers in that regard, the use of subcontracting systems, third-party management, franchising, a whole range of business organizational forms that in some ways have culminated in platform business models, but have many of the same characteristics of distancing the principal parties who benefit from work from the actual set of rights and responsibilities that we have historically built around the workplace. And that distancing, whether it manifests itself as independent contracting and essentially the complete exposure of working people to the vagaries of unequal bargaining power, whether we're talking about sexual harassment, health and safety, or assurance that you're going to be paid for work, to joint employment and very complicated, murky workplace relationships where very often, and there's more and more evidence about this, workers don't even know who their employer is if you ask or press, or sometimes are completely wrong about who they perceive to be their employer. That's the second thing that has really come to be and creates grave holes in our protections that certainly when we think about the people who are on the front line right now, the folks who are delivering packages for Amazon or delivering food from restaurants, or even many healthcare workers, including ER docs who are in third-party relationships where their employment relationship has been clouded and has, unfortunately, in a number of cases, laid them prey to retaliation for stepping up and saying that there are problems of workplace protections. That's the canvas I would paint as the area in particular I think future labor policy needs to address. And in our discussion, we can talk about some of the stimulus efforts to actually acknowledge that with respect to specific protections. What I want to end with is a proposal, and this comes out of on policy side. I could talk, and if there's interest, we can talk in our discussion about, there's a whole set of enforcement implications about how we actually make our laws real. That was certainly a major part of my focus in running the wage and hour division. But there's a wider policy question that I think, again, COVID has brought center to the table, and that is restructuring our policies themselves to address this problem. And what I'm going to do, can I bring up one slide just to talk to? Let's see. Let me see. Do I need to do the sharing, or I can share this?
You should be able to share. And if not, if it tells you not, let me know. There we go.
All right. Do you see that?
Mm-hmm.
Okay. I had to run a family Seder in 4 time zones, so got to. A fun task of learning a little bit about Zoom. So what I want to just describe is a conceptual way to think about future labor policy. And this comes out of a paper and work I've done with Tanya Goldman, who currently works at CLASP and actually worked with me in the wage and hour division, worked with Sharon during the Obama administration. And what we want to lay out is a different way of thinking about our workplace policies, our employment policies, in a series of what we're calling concentric circles, in light of these changes in the structure of business, where we say, let's think carefully about, first and foremost, what are the core rights and protections that we want to assure people related to work, not employment. And so what we outline there are a set of fundamental rights and protections that we believe should be associated with work. And those include health and safety protections, the provisions of the Occupational Safety and Health Act that assure safe and healthy work conditions, assurance of non-retaliation for the exercise of rights, assurance of non-discrimination across a range of activities. And we would also put in this core central area of rights the basic right to be paid for work undertaken, and associated with that, the provision of basic minimum wages as things we think should be linked to work and not employment. And, you know, I think most telling of the COVID crisis would be two of those rights that I've just articulated, one regarding health and safety as a fundamental thing we should be making sure the parties who benefit from work are responsible for that. And secondly, retaliation. The numerous cases we hear about people being retaliated against for complaining about exposure to health and safety risks, as well as other risks, I think are examples of that.
David, can I pose a follow-up question for clarification?
Yeah.
So in the essay that you shared, you gave the example of the doctor who was hired through, you know, a third-party management service and was let go presumably because of advocating they were doing about lack of safety provisions in the workplace.
Right, right.
So I guess I'm curious, you know, even as someone who's relatively informed about labor policies in the United States, I'm surprised that such an action would be legal. So, you know, how is it that third-party management organizations are able, you know, to do this, whereas perhaps if this person was categorized, you know, formally as an employee, they might enjoy more protections?
It's a great question, and what they did is very deft. What they said is not that they fired Dr. Lin. They said they were rescinding his appointment at that particular facility without reassigning him to a new facility. So he is still an employee of the staffing agency, where even though he had been an ER doc at the same medical facility for 17 years, they were saying, well, we made the decision independently to reassign him. Now, he was, at least the last I've heard about this particular case, he's currently reassigned to Oblivion, but he is still on the books of the staffing agency. And also important to that story was what is a very common response of the hospital that is the direct beneficiary of his work, where they said basically, hey, he's not our employee, isn't that terrible? But gosh, things happen, you know. And I think, I mean, it's remarkable in how starkly it puts this problem forward. And I think what is surprising is when we see someone like a physician in this position, you know, unfortunately, in a way, society's come to tolerate that kind of behavior for janitors and for people working in logistics firms, but it's comparable treatment. It's just worked its way up the skill ladder. But that's essentially the way they sidestep that from,
Okay.
No, it still might be actionable. You know, you can only be assigned to Oblivion so long before the actual impact of that obviously is clear, but that's the explanation.
That's helpful, thank you.
So let me just quickly, in my machine, I don't know if you're seeing the next ring. I'm not sure. Can you see the whole, all three sets of rings at this point? I'll just put it up there and not be cute with builds. The middle ring basically says after we get past these core rights, then we need to think about a set of rights that are truly linked to employment. And there we could have a broader set of rights, like the way we, or the revised way we do union representation or collective voices, as Sharon will discuss some of those issues, other kinds of rights that we tend to more closely associate with employment, where there we would argue for a much clearer definition and making employment as the default rather than the thing you have to prove. And then a variety of tests that are out there, including the one that California has adopted. We have our own take if people are interested on what that looks like. That is a modified view of the ABC test that California is using. But that same principle that a number of states are now experimenting with as being a second circle of rights. And then third, wrapped around that, are a set of social insurance access rights. Social insurance, again, as really shown by this particular crisis in regard to unemployment insurance, we would argue you want to have both employees and legitimate independent contractors have mechanisms to allow them to get into the kinds of social insurance protections that we have around the volatility of employment itself, unemployment insurance, things like worker compensation for injuries, and also accruing things like paid time off if you are operating in a maybe partially independent contracting and partially employment road. Rather than viewing that as a trade-off, as some proposals have been, for having greater flexibility, we would argue one should think about that as a broader set of rights and protections linked in this third concentric ring. And I can talk a lot more about what, why we think about that in this structure and what some of the mechanisms might be. But let me finish off with that.
So I have a follow-up question. I think I will address this question also to Sharon. I would just mention that we got 2 questions in the chat that asked about the efficiency of workers' power in nowadays to achieve some of those goals. I would leave it maybe for later on in the Q&A, for later discussion. Just a question for Professor Weil. So how should we think about the federal structure in regard to those core rights? Should workers wait for OSHA to do something universal? Should they demand the states to implement their core rights? How should we think about that in a federalized system?
Well, I think, under our existing statutes, we structure that differently for OSHA already. We have state versus federal OSHA that varies. And it's actually a very distinctive structure of that, as opposed to our mining laws, our federal preemption of any activities. Certainly, Sharon will talk about that's the way our labor relations laws are, preemption of federal activity. I think an interesting model, just to quickly answer your question, that to me comes out of our recent experience, is the important interplay of state and federal power in the regard of what I call ratcheting up of rights. So if you look at the history of many areas of legislation, this is best exemplified by minimum wage. Our federal law sets the absolute floor. States are allowed to set minimums above that. And the same is true in terms of overtime protection. If you look in the broad sweep of history of the last century, and I would argue going up to where we are right now, as states find the federal standard increasingly insufficient to go back to protecting the things Justice Hughes talks about, states have moved up their minimum wage policies. At a certain point, that creates a different political dynamic where essentially the federal government ratchets up, partly because businesses, multi-state businesses, get tired of having to comply with lots of different standards, and it moves that up. I think, and it's something that, you know, if I want to go back in history, I can give you quotes of Justice Brandeis, who was the first to really recognize this dynamic. I think that can be a very positive dynamic in moving the standards up, and also accounting for variation in those in-between times of different conditions in different parts of the country.
Ratcheting up sounds like a good idea. Yeah. So, Sharon, would you like to take the mic?
Sure. And again, thanks and echo what David said about, you know, I wish we could all be here together, because I do always appreciate the opportunity to be with my good friend and colleague. I'm not even going to say former colleague. We are still colleagues. So I want to talk about the right to organize. What I was going to do is start with sort of some of the problems in the law as it is now, and try to use some examples of how we're seeing those weaknesses playing out in what is happening in the response to the pandemic, and then talk about some of the possible solutions. But I want to start by reminding everybody that the National Labor Relations Act, which has been with us for many decades now, came about as a response to the Great Depression. Right? It was actually part of the strategy to stabilize the economy. I mean, it was seen as a positive good in trying to react to the Depression, to stabilize the economy, to get the economy moving again. And so I want to go and like shake some people on Capitol Hill to remind them of that dynamic. So I just put that out as sort of the context or a little historical reminder. But, you know, unfortunately, what we are seeing is as stabilizing and empowering as that law was, you know, 80 years ago, it is not working. It hasn't been working for decades. And I think those weaknesses in the law are really being laid bare as we look at the response to the pandemic. You know, the way I think about it is like, you can see that this response to the pandemic is happening to workers and not with workers. And, you know, another way to, not to be like glib about it, but another way to think about this or to say it is that the virus might be a natural disaster, but the consequences for workers to this pandemic is a man-made disaster. And it has been a slow-moving disaster that has been coming over the decades, but is really taking its toll now. And the main problem is that the law for many, many decades now has not allowed workers to build power sufficient to countervail corporate power in the economy or in our democracy. And those two are really sort of inextricably, I can never say that word, linked. If workers don't have power in the democracy, you know, there's like this cycle of the more power you have in the economy, that translates into power in the democracy. So we are at a point now where workers are at a low ebb in terms of their power in the economy. And so we see this unresponsiveness in our democracy to the needs and concerns and interests of workers. So to go, I mean, we could spend many days talking about all the problems in the law, but just to sort of highlight what we saw as the most important or most significant problems, you start from a place of exclusion. So way too many workers, before you even talk about the right to collective bargaining, you've got to talk about how many workers do not have a right to collective bargaining in this country. Too many are excluded from the protections of the laws. These exclusions have explicit racist and sexist origins that came about as a result of compromise with racist Southern senators when the National Labor Relations Act was passed. That's not a secret. That's pretty explicit. You know, that's why you see the exclusion of domestic workers, farm workers, at the time the act was passed, then independent contractors, but also low-level managers and supervisors. And you know, you think about the people who, for the most part, occupy those jobs, and you can see the racist and sexist implications of that. And then to bring it to what's happening today, think about how many essential workers fit in those categories. And you see that as essential workers are trying to find a way to have their voices heard during this response, you know, they're just out of the system altogether. So then moving even to workers who have the right to collective bargaining, workers have only under the law, a stark binary choice about collective representation. They have exclusive representation or they have nothing. And the problem, there are many problems with that, but one problem is just, it is just so difficult to get over that bar of choosing an exclusive representative, that the reality is that most workers in this country have nothing. And it isn't just like most, like, 51%, it's 94% of American workers in the private sector now do not have a collective bargaining representative. That's a lower rate than before workers had a federally protected right to organize. So, which I take as a very important signal that there's something fundamentally wrong with the law. And so now workers need this voice more than ever, and it's more difficult than ever to have it. There are lots of different dynamics to that binary choice problem. A really significant one is that it just gives employers an incentive to go all out in trying to defeat unionization. Okay, so moving on. Even if you can sort of navigate this difficult process and you have a right to, you have an exclusive collective bargaining representative in your workplace, the range of issues over which unions have a right to bargain in our system is way too narrow. It's wages, hours, terms and conditions of employment. If you think about that in the current context, that means that even workers who have unions probably don't have a right to bargain over whether their employers were going to shut down as a response to the pandemic, whether they were considered essential, the way that they make the decision over whether to reopen or not, are all sort of entrepreneurial decisions that workers would not have a right to demand bargaining. Again, the level at which bargaining happens under our system is also extremely disempowering. So again, you somehow navigate this system, you've got a right to collective bargaining, but you can only exercise that right, you can only demand that right in terms of your own workplace. And not and you can imagine workplace by workplace organizing has lots of problems. One, it's just really difficult. There are a lot of workplaces out there. If you think about the fast food industry, you're talking about organizing McDonald's. I mean, there are, as David has written a lot about, thought a lot about, there are issues around the definition of joint employers and the relationships between corporations and their franchises. But the reality is, in our system now, workers have to organize McDonald's single franchise by single franchise. And then they've got to do the same thing at Burger King. And then they've got to do the same thing at Wendy's. So trying to exercise power in order to make systemic change is just an insurmountable hurdle, the way that bargaining happens under our system. And it creates even more of an incentive for employers to fight unionization, right? Because they have a perception that it puts them in a competitive disadvantage as to other employers in their sector if in fact their workers unionize. I think an interesting dynamic, again, to bring it back to what's happening today, is that we're seeing some of the legislative responses to the pandemic are actually happening at a sectoral level, not at a workplace by workplace level. So we have a rescue that's designed specifically for the airline industry, not for Delta, separate from American, separate from Southwest. And so, we see corporations quickly want sectoral responses when it's in their interest, but on the other side, there really hasn't been as much of a focus on how do you give workers an ability to have a sectoral response. So I'll talk more about that in a minute and how that's working in other countries. We're also seeing a lot of collective action happening. Desperate workers will take desperate measures, right? So we have Amazon workers walking out, and we had Instacart workers walking out. But the reality is that the right to collective action under the law today has really been undermined, especially by the interpretation of the statute. The most obvious example is the fact that workers who go on strike can be permanently replaced. Now, technically, the law says they can't be fired, but for most workers, I think that's a distinction without a difference, right? And so that really chills the exercise of the right to engage in strikes. The range of topics over which workers are protected when they do walk out is also very constrained. Some of the collective action we had seen before the pandemic around issues like companies' engagement with ICE and in immigration enforcement, those are probably issues that they don't actually have a right to engage in collective action over. And so they're really taking a big risk in engaging in that activity. Again, the last topic I want to specifically talk about is the political process. So there are many aspects of our political process that exclude workers. The most significant is just the fact that workers can't build powerful worker organizations anymore, that the labor movement has traditionally been the way that workers have most effectively engaged in the political system. And so as you see the labor movement becoming weaker and weaker, that's taking workers out of the political system. But there are also ways, just that the way that voting works in our country creates hurdles for workers to even exercise that most basic right. So if you think about things like states where you don't have same-day registration and you don't have early voting, if you just think about that, what that means for workers who are working 1, 2, 3 jobs, that they have to take time off from work to go to register to vote, because often the voter registration office is only open during business hours. Well, workers work during business hours. Then they have to take time off again to go and vote. And so there are these hurdles that are built into the system that also then have the effect of taking workers out of our political system. And all of those kinds of voting reforms we're seeing obviously are going to be even more important as we figure out a way to get everybody to be able to vote in November. Okay, so those are the problems. And switch to talking about the solutions and how we've seen how some of these solutions, if in place, could be working to give workers a better response to what's going on in terms of the pandemic. So my colleague here at Harvard Law School, Ben Saxon, I started this project about 2 years ago. We call it Clean Slate for Worker Power. And the purpose of that was to think about a new labor law that would be capable of empowering all workers to demand a truly equitable American democracy and economy. So we brought together academics, advocates, union leaders, activists, all kinds of people to produce recommendations for a comprehensive rewrite of American labor law. And the question that we put to everybody involved in the project was, what would labor law look like if, starting from a clean slate, it was actually designed to empower working people to build this equitable economy and politics? And so our answer comes in the form of a detailed set of policy recommendations. You can go to our website, read it. The report's about 150 pages, because here's a big surprise: it's relatively complicated to rewrite the rules for the American economy. But the guiding principle is that the law needs to enable workers to countervail corporate power wherever corporate power impacts workers' lives. So it means a labor law that equips workers to build power, not just at the level of the individual workplace, but across enterprises and industries, in corporate boardrooms, and in our political democracy. And that those solutions have to be universal. So we've got to get rid of these exclusions that take so many people out of those protections. The biggest change probably that we propose in Clean Slate would be for labor law to allow workers to build power and engage in collective bargaining across whole industries, not just individual firms. So this is creating a sectoral bargaining system where agreements would cover all employers and all workers in a sector. So regardless of whether they are designated as employees or independent contractors, regardless of whether the employer is actually sitting at the bargaining table or not, you create conditions across the sector. So again, think about it as an agreement between unions and the fast food industry, not even just unions and the McDonald's Corporation, even if you could pull all those franchisees.
Sharon, just a follow-up question for
Yeah.
folks who may not know. Are there laws in the United States that preclude or make it illegal to engage in sectoral bargaining? So is there actually something that would prevent, for example, the National Restaurant Association from engaging with, unions in that sector and coming to a sector-wide agreement?
So it wouldn't preclude them, but it gives them the veto power, right? It is up to them whether to do that or not. Workers
Meaning
can't
the business
demand.
association.
Yeah, workers can't demand bargaining at a level beyond their own company. It's an employer can always say, no, we don't want to do that. And there's nothing workers can do about it. They can't strike to make them do that. That would be an illegal strike. They can't refuse to bargain just at that workplace level. So it's completely disempowering. Now, we've seen there have been instances where unions have gotten so strong in a sector that they've been able to bring multiple employers to the table. Like the most obvious example is the auto industry. But now we see, as the transplants have come, the foreign auto companies have come, we don't have sectoral bargaining in the auto industry anymore. We have sectoral bargaining among American companies. And that's a lot of what has really disempowered the UAW, which used to be one of the most powerful unions in the country. Mm-hmm. But they're now being undermined by these non-union foreign companies. And there's no way for them to force them to the table.
Okay, that's really helpful. Thank you.
So in thinking about sectoral bargaining, and I think Gali circulated this op-ed I wrote for the American Prospect, trying to point out how sectoral bargaining is helping other countries, because bargaining happens at the sectoral level in almost all of the rest of the world, certainly most of the industrialized world. So we know, like we can see in Europe, these sectoral collective bargaining tables have been the locus of both helping workers figure out, those who have to work during the pandemic, like how to adjust their work conditions to better adapt to, the sort of necessary changes that have to be made. But really importantly, also helped European countries respond in terms of their relief efforts much more quickly. So these sectoral bargaining tables were sort of the locus of these tripartite agreements between corporations, unions, and the government as to what that relief should look like. And the example that seems to be working the best is in Denmark, right, where they very quickly got together and came to an agreement among the three sort of what in Europe you call social dialogue partners, that the government should just take over payrolls at it's like 80 or 90% for the next few months, just to best protect the economy and to protect workers. And they could do it quickly because they had this mechanism there where the parties all, were used to engaging with each other and coming up with big answers. In Germany, you saw in the fast food sector, again, fast food companies sitting down with the union that represents fast food workers, coming to an agreement pretty quickly to cover 90% of fast food workers' wages for at least the next couple of months. That's a very different reality than what McDonald's workers are facing in this country right now.
While we're on comparative examples of how sectoral bargaining, has worked in other countries, Tammy Katsabian from the chat posed a question I wanted to bring up because it's on this topic. So, her question is that, one of the difficulties in sectoral-based unions could, at least in theory, be, that of getting majority approval. So the larger the bargaining unit, potentially it's harder to get certified. So her question is, how can we deal, with that difficulty? Are there examples where that's been handled well?
Yeah, so for the most part, when you have sectoral bargaining, it's not a majoritarian process. So what it is, it's designated by legislation that there shall be sectoral bargaining in either all sectors, or you could imagine a system where you prioritize different sectors. You have a way of designating representatives who want to come to the table on each side. They come to an agreement, but then the way that it is extended to the entire sector is through the process of like regulation. Essentially, you would have in this country, you'd probably have like the Secretary of Labor promulgate as a regulation the terms that were agreed to at the sectoral bargaining table, so that everybody is covered regardless of whether they were part of the negotiation or not. That's not the way it works in all countries that have sectoral bargaining. There are countries where, everybody just comes to the table voluntarily. That is an unlikely circumstance in the United States. So we would probably, what we recommend is a system that looks a little bit more like France, where you'd have this idea of like contract extension. It's what they do in South Africa also. But obviously you have this incentive for folks to come to the table because they're going to be subject to this agreement. So they might as well come and try to, have it come out the way that they want it to.
Right.
So another recommendation that we make, if you want to put workers sort of in motion and have these rights and exercise rights to engage in collective bargaining, to engage in more collective activity, we thought it was really important that we look at ways to make sure that workers are secure enough to take advantage of these new opportunities. So we recommend that all workers in the United States be entitled to just cause protection from discharge. So as most of you probably know, the US is one of the few countries to have what we call at-will employment as the dominant model. Unless you have an employment contract, you can be fired for what we usually say is a good reason, a bad reason, or no reason, as long as it isn't an unlawful reason, which is like a reason motivated by race or sex discrimination. And again, to bring it back to what's happening today, we see, as David was talking about, workers being fired for raising concerns about safety issues. If you sort of flip the default as you do in a just cause system, it makes it harder for employers to take these kinds of retaliatory, engage in these kind of retaliatory discharges. Last, just want to talk really quickly about corporate governance. Although this is outside of labor law, we did think it was really important to make sure that workers have a voice in corporate boardrooms. So we look at recommendations like workers on corporate boards, changing the fiduciary duty to include a duty to workers, not just to shareholders. These changes seem more urgent than ever. Look at really trying to learn lessons from the response to the Great Recession and certainly to last year's massive tax cuts. We know we just can't trust corporate boards to think about anybody other than CEOs and shareholders. And at this moment when we're literally sending trillions of taxpayers' dollars into corporate coffers, it seems really important that there is more accountability and more of a check. And then the last thing, I just want to respond to what David said about preemption. So in labor law, federal labor law does preempt very broadly any state level regulation of collective bargaining for any workers who are covered by federal law. We do recommend lifting that preemption, trying to set federal law as a floor, but let states ratchet up, as David says. That's hard to do, just to be frank. It's hard to do in labor law. Minimum wage, I'm not a numbers person. Even I know if $15 is higher than $7.25. In labor law, it's a lot harder. That's a qualitative judgment as to what's more protective. So we tried to come up with a system where you could make those judgments and protect those judgments, but we think that innovation that happens in the states is important even in the area of labor law.
Great, thank you both. That was really helpful and really insightful. So I'm just going to take it away. We have a queue of questions going on here. So both of you had sort of hinted at, and Sharon, I think you used the language that the National Labor Relations Act starts from a place of exclusion, particularly around race and class lines, and David certainly hit on that in his presentation as well. For some clarity, I have a sort of a two-part question. One is, how is bargaining or the opportunity to negotiate with employers legally limited for those who are not covered by the NLRA, right? So what types of actions are illegal absent the representation of a union? And related to that, Tova Wang, brings up the question that given misclassification of workers is unlikely to end soon, what levers of power are actually available to them? So, David mentioned the strikes of Instacart and Whole Foods workers recently. Are those strikes effective? Are there other mechanisms?
I'm happy to start, especially with the first question about what is illegal if you don't have a collective bargaining representative. So it's actually illegal if you don't have an exclusive collective bargaining representative, meaning you haven't jumped through all these hoops and been able to demonstrate majority support to engage in any kind of collective bargaining. You can't, or at least that is the way that the law has been interpreted. There is a debate over if that's the way it should be interpreted. But what some people call minority unions or members only unions, at least the National Labor Relations Board so far has said are not allowed. So it would be unlawful for an employer to sit down with any subset of their employees and say, okay, you came to me, you want to have conversation, let's figure this out. And there's nothing that compels an employer to sit down with a subgroup. So again, we have this all or nothing system that really works to exclude almost everybody.
Let me pick up on the misclassification question, which is a good one. And if I'm understanding it, it's basically saying, what do we do now without maybe federal changes that could address that? And I think there are three different channels that, and this isn't theoretical, we have seen these all have efficacy in regards to misclassification. First are state laws. I mean, and it gets back to the federalism point that we've both been discussing. States have, in the absence of federal activity, moved very aggressively in different ways to address misclassification, with the legislation in California known as AB 5 being one of the best examples of that, which is now being echoed in New York, and a number of other states are trying versions of that. And that's an explicit redefinition of how you draw the line and the defaults. And I think that's been a movement that's grown out of a second arm, which is advocacy I'll talk about. But I would again make the ratcheting point. That has impacts beyond just the states where they're being adopted, in terms of changing essentially the political dynamics of ultimately allowing federal legislation to happen. So that's number one. Number two, at the federal level, and this was, one of the major focus of during the Obama administration of the Wage and Hour Division, and that is to say, we can enforce the law in a far different way to actually make, even under existing definitions, it very clear that most workers are protected. We issued during the Obama administration something called an administrator interpretation that still keeps people, I guess, up in the Chamber of Commerce up at night who are still reacting to that, which was a piece of guidance that was based on what courts had been saying about the Fair Labor Standards Act, which has the broadest definition of employment of any federal act, a definition I still embrace and love, which is to suffer or permit work is basically the standard that the FLSA applies about whether or not you have responsibilities, either as a employer or as a joint employer. What we found was we weren't using the tools we had to adequately enforce that law, both through things like guidance and making clear, but then through the coordination of our own enforcement activities and in partnering with our state level government agencies in a way that hadn't been done before. So we were leveraging our collective ability to enforce and reaching out much more actively to worker advocacy organizations and unions in undertaking that work. And I think we showed how much further one could go through a very basic strategic, what we call strategic enforcement approach to that. So that's the second prong. The third prong is the amazing work that advocacy organizations have done in the misclassification space and protecting workers in general. You know, the Fight for 15 movement really took fire when Sharon and I were in the administration, when there was outside of our walls an incredible force changing the nature of the debate, partly because the Republicans had stopped any efforts to raise the minimum wage through the federal minimum wage. The Fight for 15 movement, I think, in many ways changed the nature of the debate about what should be the minimum wage and how we should define who should or shouldn't be covered by it. And so it's then the intersection of all three of those things that to me is powerful in thinking about and makes me optimistic in these dark times. One of the things I do look back on and I look at right now are the interaction of these three prongs over time is how we have always moved the dial and how I think we will continue to do so going forward.
If I could just quickly add something around misclassification. I mean, obviously it's a huge problem that needs to be fixed, but there are interesting experiments. So the only upside to being misclassified as an independent contractor is it means that you're out from under the National Labor Relations Act. So that's bad, but in states where there is a willingness to experiment, we're seeing beginnings of efforts to create collective bargaining systems for workers who are not covered by the act. So, you know, one of the examples was in Seattle. They tried to create a collective bargaining ordinance for TNC drivers. Now, there were legal issues, but I think there's still a lot of interest in seeing if that could work in different places. In the state of Washington, you have the beginning of a sort of tripartite collective bargaining kind of process for domestic workers. And so where, you know, one door closes, there is a little bit of opportunity to do something different. And considering how weak the National Labor Relations Act is, you know, for some workers, if you really could come up with the right system, it could be more empowering, at least in terms of collective bargaining, leaving aside all the problems with being, you know, excluded from the rest of the social safety net.
That's great. And it resonates with our conversation we had last week with Working Washington and their efforts to represent contract workers there. So I do want to get to this question posed by Ben Routledge, given both of your experiences in the Obama administration. So he asks, how can we best frame the arguments for a revised federal labor law in a way that would achieve bipartisan support that we would presumably need to pass it? You know, are there, you know, how do we get skeptics on our side is basically what Ben asks.
And I have a kind of a riff on that. So there's a value theme that the state should be neutral as to the power struggle within the workplace. The state should be neutral whether workers are unionized or not, or the state should only intervene to the point of correcting market failures, but then kind of keep off And I think that those two questions about political feasibilities and the values of labor law are connected. So what would you say to those two kind of views on future labor policy?
Again, I'm happy to go. David, do you want to go?
You start. I'm sure.
I might say something that I know this is being recorded, whatever. I actually don't think that getting bipartisan support is the way that you win labor law reform. I mean, it is just, I have worked, I came from Capitol Hill before the Obama administration. I had the great privilege of working for Senator Kennedy on the HELP committee. I can assure you that if you wanted to change a single comma in the National Labor Relations Act, the Chamber of Commerce would instantly raise millions of dollars to fight changing a comma. And they would have many supporters on Capitol Hill who would be willing to carry that water for them. I think our theory in Clean Slate of how this happens, sort of taking it maybe out of a strictly partisan lens, but you can, put that lens back on if you want, is that you build a vision of what reimagined labor law could really do for people, how their lives would be different, how this country would function differently, and you build a movement behind that, which then puts pressure on elected officials to realize that vision. But I don't see this as like just my long experience doing this is that it isn't a like, let's find a middle ground way to do this. Now, I think there are some aspects of labor law reform that maybe in this particular moment might have more currency just because of the just profound evidence of how workers are being kept out of decisions that have to be made, and that the efficiency of trying to figure out how to bring workers back to work especially is going to require some kind of collaboration. So working with some folks around thinking about what that kind of collaborative mechanism could be in this, that attends to this particular moment. But in terms of really writing US labor law, I don't see that in this, the way things are now, as a bipartisan project.
Yeah, let me pick up on the other parts of law, because I mean, I certainly agree with Sharon that labor law has always been the third rail of politics, and has drawn the most rigid and monolithic opposition from the business community. Now, I think that is also still compounded by the preemption, that there's never this kind of countervailing force of differences occurring at the state level that keeps the monolith together. And so it's made it even more impossible to envision a bipartisan effort. I think, in other areas of employment, workplace policy, I think there are opportunities that do come from the federalist, the differences there. That's one source. I think there was a period of time where people, even on the Democratic side, tried to fashion workplace policy arguments completely around efficiency. And, the breakdown, to your point, Gali, only where you saw markets not working efficiently was there an argument for intervention. Now, on one hand, and maybe this is because I'm warped because I was trained in economics, I think we have to be attendant to those kinds of views, that we have to understand, Sharon mentioned in one of her earlier remarks, the complexity of the economy. I always find economics a useful framework, in part because it makes one attendant to the fact that, it's like a bubble in the carpet. The way markets work, you can stomp on a bubble in a carpet, but it tends to pop up elsewhere, unless you understand how the carpet is laid. And I won't push that analogy any further. So we do have to understand the efficiency of markets. But the reason I started my remarks today, and I more and more ground them in this, is let's not forget the fundamental thing that makes a labor market different than other kinds of markets. And that is this unequal bargaining power that is a fundamental feature of the labor situation, the workplace situation that we have always acknowledged and need to build in. And that means that that's got to be part of the political debate. That means, saying, hey, we're all, doing right by doing good, which is a phrase that is often used, that we're all in this together. There is a piece of that, but I don't view that as getting us far enough. If we had waited for that, we would never have the Occupational Safety and Health Act, much less the Fair Labor Standards Act, and certainly not the National Labor Relations Act. So I think we have to be cognizant of the importance of that basic recognition of really a justification built around fairness, fundamental to what we do in labor policy, and then building political coalitions accordingly.
Great. Sharon, how would you respond to the claim that there's something in the culture of American employers that reject a more coordinated type of economies? Like you gave the example of Denmark, but maybe there's something in this inertia of 80 years fighting against unions, fighting against collective attempts of coordination that have a staying power. It's not something that you legislate and then things change. So is that a right frame to think about it? How would you think about that problem?
I think that's right. I think our culture is really different, certainly than a lot of the countries that have robust sectoral bargaining systems. I just think it's something we have to change. We also have a culture of treating workers incredibly badly. And so I think we can't just accept that as a background fact. So it's not I totally agree, it's not just a problem you can fix with legislation. I think it's like, it's got to be a culture shift, but I do think that the labor law is a really important piece of getting that change started. Again, I think, I don't want to call it opportunity because God knows, like, everything that's happening now is horrible, but I think it's fair to say there is a good chance that our economy is going to be somewhat reordered by this disaster. And again, we're all, the airline industry came to Congress together as a sector to say, help us. We have to do this as a sector. I don't know where that's going to go, but I think this may be a moment to break through some of that culture. I certainly think that people who care about workers should be demanding even more than they have so far, as there are going to be more legislative responses, that we find ways for workers to have a voice in a way that's meaningful. And I think that has to happen to some level, to some extent at a sectoral level.
We have another question from Tammy that is related to this. So, both David and Sharon have brought up, pretty broad sweeping proposals for reform that would assure non-discrimination, a basic wage, health and sick leaves. Sharon, you brought up systemic issues of access in our political system. So related to that, Tammy, asks whether this is really an issue of labor law or broader issues within the American, social welfare state is what she brings up. And I want to make sure I get the full of her question. So let's see. Yeah, so I think she's curious to hear your reaction to that, and are there ways to deal with these issues that maybe wouldn't be through labor law, but through reforming other parts of the American welfare state?
So I think maybe riffing off Tammy's question, why focus on the workplace? If we want to create community-wide effects, why not go for measures like UBI? Or why connect all of those things that we are now connecting to the workplace in US workplace regulations and just like detach it perhaps like in Wales offer. So why focus on that as the locus of kind of regulating power in the community, regulating distribution in the community?
Well, I won't talk about UBI because I don't want to hyperventilate. You know, I think about, I think it's a great question. I think about it in two ways. You know, there are certainly issues that we need to take out of the workplace. I mean, that's what the ACA was about. That's what healthcare for all is going to be about. You know, and that has made, you know, these last 6 weeks have made it abundantly clear about why that needs to be the case. And I think the political debate there will be reshaped by our experience with this pandemic in terms of healthcare. I'll let Sharon talk further about, you know, I think the political piece of what she already described, I think is something that goes beyond the workplace, the disenfranchisement, the horror of what we saw in Wisconsin last week played out as a whole, I think speaks to Tammy's question writ large in the political space, that it has to go beyond the workplace. But where I would say many of these issues do emanate, not solely, but from the workplace, has to do with, number one, work gives meaning. There is a lot, I mean, it's one of the reasons I do object to the UBI notion, is that it somehow implies that work has meaning only for people who have, you know, high-tech jobs in Silicon Valley, where that idea came from, and everyone else would just rather be paid to do nothing. I you know, again, I think we see the value of work, of people taking the risk to deliver food to your doorstep. That is not a trivial act. And we got to start recognizing that as meaningful work. And I think people are, this experience has made them aware of that. So that's one domain. The other domain, which we haven't talked at all about, but is a huge long-term change. President Obama, you know, talked about this as the defining issue of our time, and that is economic inequality. And the fact that we have more and more evidence, I would point you all to a new paper that just came out in the Proceedings of the National Academy of Science that shows internationally the growth of increased inequality arising from differences between firms, that I think, and the paper argues, is really a function of two things. One are the kinds of labor protections, particularly around the dimensions Sharon's been talking about. And secondly, because of the fissuring of the workplace, that we have this growth in inequality that I think does emanate fundamentally from the workplace, and therefore many of the things we've talked about today have implications about changing that trend that have gone to alarming extremes, not only in this country, but as this paper makes clear, in many parts of the world.
Yeah, I mean, I don't have a lot to add to that. You know, I think it's again, it's not an either or. Like, you know, we need to be building power for consumers. We need to be building power for tenants. But I think, not that we should always do things the way we've done before, but the reality is that building a powerful labor movement has been the best way in the past to build a more progressive agenda. That's, you know, to build a more responsive politics, so that you can then build the, you know, other avenues of power. So I think it is a piece of it. It's not the only answer, but it has proven to be an important piece of the answer.
So I have one more question for both of you, and I think if we don't have any more, then this would be the last one.
That's
so I
right.
want to talk about enforcement. So Professor Weil, you mentioned it in your remarks. So I just want to give two figures kind of to ground my question. So according to a recent book by Mike Piore, the Department of Labor Wage and Hour Division visits a workplace every 58 years. OSHA visits a workplace in average every 66 years. So are those the relevant numbers to understand enforcement? Should we look at other things? How does enforcement look like in your kind of vision of workplace regulation?
Well, I would start, but that's just the start of figure. I mean, that is the inherent problem of enforcement, that you will never have enough investigators. President Obama brought the wage and hour division by fighting with Congress every year. We got to a level of 1,040 investigators was the peak we ever got to. He tried in every budget to increase that for the wage and hour division. It's now my best guess from things I hear. There are only about 700 investigators in the wage and hour divisions because there's been this letting open positions stay open. But what my point would be is, even if you double the number of investigators we had, so if you get to 2,000, you still face the fundamental problem of 2,000 investigators for 9.5 million workplaces with the complexities of our economy is a very tough thing to do. And that's why we focused. I think there are ways why those numbers only start the discussion. Thinking differently about how you deploy investigations, how you use and work with other institutions in society, how you use deterrence theory, how you use publicity, how you use the bully pulpit that any enforcement agency actually has. You bring that to bear, and then focusing on the places where the biggest problems are and using those tools gives one a far more, it makes one much more able to have efficacy in what will always be a resource constrained situation. So while I agree that, you look at those numbers and they sound pretty dismal, I frankly get a little irritated when I have academic people who leave the discussion at that, and then sometimes go to points. And I'm not saying Mike says this, but I know other people have gone to the point to say, you see, so you can't depend on government to do it. I think that is the wrong road to say. It says you need robust government. You need effective government. We should be thinking about the importance of a career service that brings in really good people. Sharon and I had the opportunity to see how good public servants, career servants are, and how much they want to do their mission, and how far that can go. So I think it is a strategic approach to how you use those limited resources. That's the key.
And final question for Sharon.
Yes.
So what would you put in the next stimulus bill or effort to promote your kind of ideas of a progressive labor law? So you would condition support with sectoral representation. How do you think about that?
It's something I'm thinking about a lot right now. So I want to be a little careful not to get ahead of where some of the conversations are on the Hill. But I think what group of us are thinking about is some kind of requirement that there be some kind of sectoral mechanism to navigate these issues that are directly related to the pandemic. So safety and health, paid sick days, hazard pay, the conditions for reopening, that where workers, and business and the government are all represented. So I'm not exactly sure. We're trying to think through some of the details on what that would really look like. But think that's a really important piece. And then as, hopefully some point, this is terrible that this is what you hope for, but that we shift to a less of a response to a public health emergency and more of a response to an economic emergency. You might then shift what those topics look like.
Cool, amazing. Any last comments,
Stay
Johnnie?
tuned.
No, I think we can wrap up with that. In closing, I did want to mention that Gali put the link to the Clean Slate report in our chat, which I think David and Sharon were both involved in.
Yep.
So I encourage folks who are interested to take a look at that. And I also found that paper that David mentioned. So I will be reading that in the next couple of days for sure. And those interested can go to that link and I'm sure get access through Harvard, hopefully. So thank you both. And thank you to all our participants for joining us this semester.
Thank you so much.
Thank you.
Great. Thanks, everyone.
Bye-bye.
Bye.